Okay, this has been the March 26th, 2012 meetup called the Austin Constitution Meetup Group. And we have just been listening to the oral arguments made today in the U.S. Supreme Court. So this has been the first of 3 days of arguments. The issue in the arguments today was whether or not the Supreme Court has jurisdiction to decide the case now, or whether it has to wait until the first taxes have been paid, and then it would provide standing for someone to challenge the tax. And neither the government nor the opponents to the Health Care Act may take the position that it is a tax. They all argue that it's a penalty, and if it is a penalty, then the 1867 Anti-Injunction Act and subsequent acts pursuant to that, which bar the federal courts from enjoining the collection of a tax until after it's been paid, do not apply here because it's a penalty. And therefore the court can go ahead and decide the other issues of the Affordable Care Act on their merits. Now, the court felt, because some lower courts had dismissed the suit on grounds of lack of jurisdiction under the Anti-Injunction Act, that it needed to address the issue. So because neither the government nor the other litigants were willing to make that argument, they appointed a special counsel, a fellow named Long, to make that argument to the court, whether he believed it or not. You know, their lawyers are hard guns, and they're often appointed to argue positions that they don't necessarily believe in. And so the court began the argument today with Mr. Long making the argument that the court does not have jurisdiction. And then we heard from the government, the Solicitor General, Borelli, and then from one of the lawyers for the litigants, primarily the state of Florida, Mr. Katzis, who of course also argued that it was not covered by the Anti-Injunction Act. Now, to understand what you've just heard, all this argument about whether it's jurisdictional or administrative, if it is jurisdictional, then the government may not waive its right to not have the court hear it. But if it's only procedural, in other words, it's not denying jurisdiction to the court, it's only delaying it to a later time and requiring that certain other things have to happen first. In other words, somebody has to pay the tax, they have to apply to get it back, they have to exhaust administrative remedies and so forth before the court can hear it, then it may be waived. And where this question turns on then, because if it may be waived, then the government, by not invoking the Anti-Injunction Act, as it has not here, has effectively waived it. So, by deciding that it is not jurisdictional, and noting that the government has waived their claim under the Anti-Injunction Act, they have effectively set it up for denying the Anti-Injunction Act argument, accepting jurisdiction, and moving on to deciding the other issues in the case. Now tomorrow the argument will be on whether or not the individual mandate is constitutional. And on Wednesday, the argument will be on the state's claims that the Affordable Care Act, by invoking an increased demand for services under Medicaid, which the states have to pay for, will burden them, and that such a burden constitutes a justiciable injury. So we have several groups of litigants that are involved here, and tomorrow we move on to what is really the heart of the issue, is whether or not the Affordable Care Act, individual mandate part of it, and therefore the penalty, is constitutional. And the issues there will be whether the Commerce Clause through the Necessary and Proper Clause affords Congress that authority. And I would say that tomorrow's oral argument, which should be available about midday or late tomorrow, at the same website, acalitigationblog.blogspot.com. You'll be able to listen to it and to hear how the argument went. Now, I think today we've heard that almost all of the justices were highly dubious of the argument that jurisdiction is barred by the Anti-Injunction Act. Then what most of them seem to be most impressed by is simply that Congress in the act did not call it a tax, it called it a penalty. And in all the other cases that they examined where it might have been borrowed as a tax, there was always some reference to the amount as being a tax. So in this case, it would seem that Congress itself has barred itself that remedy. And therefore, we may move on to the Commerce Clause argument. Now, if the Commerce Clause argument succeeds, then we go on the following morning, Wednesday morning, to the question of severability. Because if it strikes down the individual mandate, then the question arises whether the rest of the act can go on without it. So the court could decide that the individual mandate is unconstitutional and strike it down, but also say that the rest of the Affordable Care Act shall stand. Or it could say that the provisions are not severable, that because the individual mandate is unconstitutional, the entire act falls. And I think what we've heard a taste of here today is the justices expressing some doubts, not too clearly yet, we'll hear more of that tomorrow and the next day, whether or not the Affordable Care Act is viable without the individual mandate. And indeed, I think we've heard a lot of questioning today about whether or not the entire act needs to be reworked because it's so inartfully written. Now, one of the arguments that we did not quite hear today, which I was waiting for and expecting, but we didn't hear, is that Congress in the act specifically excluded, even though it said that the individual mandate shall be collected like a tax, it excluded the use of such remedies as levies and forfeitures. In other words, the government may not seize assets to collect the individual mandate. And of course you might ask, well, if it can't use those enforcement mechanisms, what can it do? And the answer is, and this probably should have been brought out, is that if a person has a job where his employer is withholding taxes and sending them to the government, then the IRS may take the individual mandate out first and then levy a deficiency on him if he doesn't include the roughly $700 in what he pays in taxes. So it could say, okay, your employer has collected $4,000, and you would owe $4,000, but you also owe this $700 for the individual mandate. So we're taking that out of the $4,000 that was collected, and by the way, now you owe $10,000 in interest and penalties on the $700 you didn't pay, not for the individual mandate, but from the rest of your taxes. That wasn't brought out, and I think it really should have been. So, we have a rather complicated collection of cases here. Now, and I would say that if the individual mandate is held to be constitutional, that the state's claims will probably follow. So they can make their arguments on Wednesday, but I would say that their cases depend entirely upon the arguments that will be made tomorrow. So basically they all rise or fall together. But the states can't make the arguments that are being made tomorrow because there's an old Supreme Court precedent that a state does not have standing to defend the rights of its citizens in what's called in parens patriae. In other words, the old common law doctrine was that a government entity, a state, could defend the interests of its citizens. And in 1923, in a case of Massachusetts v. Mellon, the court ruled that a state does not have standing to do that individuals have to sue on their own. So what is happening in this bunch of cases, this consolidated case really, is that all of the individual interests are represented by these various non-state entities, most notably the one that the lead litigant is the National Federation of Independent Businesses. The lead counsel for which is Michael Carvin, and assisting him is Randy Barnett. Now, what I also participated in this morning is the oral arguments were discussed by a teleforum of the Federalist Society, which you can call in on. I'll send the link to the group. Randy explained what he had just witnessed in court, and then the questions. Of course, I always get the first question. And we got into a discussion of something that I have sent to the group before, which is my outline of arguments for on the question of the original meaning of, quote, carrying into execution, unquote. And that phrase has never been litigated, never been decided by the Supreme Court, but in my view is more restrictive in some ways than necessary and proper. And what I did is set forth the arguments which were made in a sort of tentative way by Carvin in his NFIB brief, but which I encourage Randy, and through him to Carvin or any others who appear before the court, to sharpen their oral arguments on this point, because I think it's the strongest point they could make. And what I did in the outline I sent them, which is also a blog article, is I laid out, argument, statement by statement, exactly how to make the oral argument if they should choose to do so. The outline was prepared in anticipation of being able to file an amicus brief myself, together with some other people, one of whom is admitted to the Supreme Court bar, which I am not. Amicus briefs have to be filed under current practice by lawyers who are admitted to the Supreme Court bar. So he was willing to do it, but he had a pre-scheduled vacation, and with him being out for more than a week, we just lost too much time, and we ran past the deadline from when we could submit the amicus brief. However, not too late for me to approach the lawyers individually, encouraging them to make this oral argument. So that's what I've been busy doing. I say now, if you have any questions, it's time to ask them.
How can you possibly formulate questions on such a morass?
Well, I'm sure you heard during all this, there are some very quotable moments during this oral argument.
Inarticulate structure?
The justices themselves, some of their quotable moments, but of course, the one I liked the best was made by Mr. Long when he said that nowhere in the tax code does it define what a tax is. Okay, I'm going to go through the transcript and lift that out and make that the subject line for an email that's going to go out on the subject, because I think that is more telling than almost anything else.
Yes.
So one of the things I try to do is to mine things like legal briefs and oral arguments for good quotes, and that certainly has to stand as one of the best.
I'd agree. That's head and shoulders above all the rest.
But of course, it also shows that the Affordable Care Act is running up against some very challenges to the quality of its draftsmanship. I mean, it's essentially what I see happening, and the reason why I think we're going to win is because it was written in such haste, so poorly, that it's simply going to fall because of poor draftsmanship. I think
one thing that was really obvious, we're talking, this is arguments before the Supreme Court, we're talking Supreme Court justices audibly, I think at least each one of them, and certainly multiple times, using the word confused.
yes.
That is, it's dumbfounding.
Yes, and I think the general quality of the questions and comments by members of the Supreme Court in this oral testimony today was very high. These judges are very engaged. They're asking good questions. They know their subject matter cold. The only one we didn't hear from was Justice Thomas, And of course, he usually keeps quiet. He speaks when the time comes to write his opinion. But all of the others chimed in, and they were right on top of the issues. They had read all the briefs, they knew the arguments, and they're, I'd have to say, intellectually, among the best that we've had in a long time.
It was also amusing to note they were joking about the interchangeability of the word tax and the word penalty.
Yeah. Now, interestingly enough, I would say that the justice who is most likely to sustain the act is Breyer. I'm hearing a lot of skepticism from even the usual liberal justices. And it wouldn't surprise me, you know, if everybody's expecting a 5-4 decision, it wouldn't surprise me if we got a lot more than 5. So it remains to be seen, but I have a good feeling about how this whole thing is going. But of course, I will naturally be listening carefully to the oral arguments made tomorrow and the next day, and of course the commentary thereafter. So this is a very interesting and exciting time in our nation's history. Depending on how this case is decided, we're going to have a vastly different legal landscape than we've had before. If the Affordable Care Act is sustained, then it will be an important nail in the coffin of our rights under the Constitution. On the other hand, if it is overturned, it almost certainly begins a process of unraveling the entire line of precedents that goes back to the 1819 case of McCullough v. Maryland. It's very hard to see how, if the court can split the difference so finely that it doesn't begin to unravel the New Deal. And that becomes very important in itself, and I'm sure the justices are fully aware of that. If any of them want to, overturn the Health Care Act, some of them are going to be struggling to find a way to do it that doesn't begin to unravel almost 200 years of precedents, which they're probably reluctant to do, but the logic may force them to do it. And of course, it also illustrates the problem of what happens when you start departing from strict compliance with the Constitution. Eventually, you get to a point that's so absurd that in order to make the right decision, you have to start unwinding. And that seems to be the situation we're in now, and we have to get out of here in 5 minutes. So, any questions, comments?
Was it ever established who had the compelling interest to put forth the anti-jurisdiction argument, or what was the compelling? What was the party involved in that?
Well, the Long is the only one that argued the jurisdictional angle.
So it was largely redundant?
Well, it was largely, yeah, because he was appointed by the court to argue that position that neither the government nor the litigants adverse to the plaintiffs, essentially, were arguing. So he was the only one on that side of the argument. And the court had to drag somebody in from the outside in order to get anyone to make it. So right off the bat, I'd say that's a very weak position. So I don't think that one is going to be sustained. The key issues are going to be argued tomorrow and the next day.
Can you give a brief description or contrast between the a lot of this was the AIA, which is Anti-Injunction Act. A fair long way into it, reference was made to the Tax Injunction Act. But is the Anti-Injunction Act what prevails when it's basically if there's not a question of jurisdiction, it's something the Anti-Injunction Act can address, or is there a good way to compare those?
Well, the Anti-Injunction Act has been variously held to be jurisdictional or procedural. But the argument today was almost always on the side that it's procedural. In other words, it doesn't actually remove jurisdiction from the court. It only defers adjudication to a later stage in the process.
Okay. So the Anti-Injunction
But of
Act
course, even if it's not jurisdictional, the argument can be made that procedurally this case should be deferred until a later time. But if it is jurisdictional, government cannot waive its rights to invoke it. Whereas if it's merely procedural, the government can choose not to invoke it and therefore let the court decide it right away.
So anti-injunction would basically keep it from the court.
If the government chooses to invoke it, if it's procedural. So these are sort of esoteric legal arguments. It's the kind of thing that I have to contend with all the time. I'm constantly involved with the lawyers, including some of the litigants in these cases, you know, arguing abstruse points of law. But this is where the real battle is on these issues. Most lay people have only a dim understanding of the legal points. And to really understand the issues, they need to have a better grasp of them than they do, which of course is why I am making this video and hoping people will listen to the argument and will watch my video and visit the ACA litigation blog and read the briefs and so forth. It's a lot to slog through, but it's well worth it, because a lot of things will begin to emerge as you get involved in these minutiae of legal arguments. But it does help to have somebody to kind of guide you through initially. But again, we need to leave. So. You can shut
Say
it down.
anything to
Red button.